Mr. Finlayson, good morning. Thank you for being with us. We've got you for 10 minutes this morning. You're currently on mute. I'll allow you to unmute and I'll hand over to you.
Thank you, Mr. Chair, for your guidance and technical expertise, and congratulations on your elevation. As Dr. Webb will tell you, such honour passes reasonably quickly. I've got a very brief submission to make on behalf of the Bar Association, which is, if you like, the independent bar version of the Law Society. It has about 1,200 members. You have the submission. I don't intend to refer to it at any length, simply to make the point that above all the bill is misconceived. Because it endeavours to raise a number of principles that simply do not reflect the relationship of the Treaty of Waitangi between the Crown and tangata whenua. Frankly, they're principles that could possibly go in a written constitution, although they're not particularly well drafted, or possibly be included in the Constitution Act, but they don't belong in the Treaty of Waitangi Principles Bill because they don't accurately define the treaty relationship between the Crown and tangata whenua. Happy to answer any questions.
Thank you, Chris. I'm sure Duncan and I will make sure your South Island passport was in the mail already. I'll go first to Dr. Webb, then we've got one from Ginny Anderson.
Kia ora, Chris, really good to see you and hear from you on this forum. Really interested in, we've had some discussions around parliamentary sovereignty already, and you use quite a nice phrase, Parliament sovereign but not omnipotent. I'm just really interested in you just giving a minute on what you mean by that, and in what ways do you think Parliament's power to do whatever it wants is in some way constrained?
Well, it's a topic that comes up from time to time, Dr. Webb. You will recall, of course, what the late Lord Cook said, that there are some things that may be beyond the competence of Parliament, like abolishing the judiciary and so on. So there are obvious limits. And one such limit is to start to interfere with the Treaty of Waitangi, which stands quite apart from parliamentary sovereignty. So, as I say, the Parliament can legislate to provide that the earth is flat and so on. It doesn't make it flat, but this is an issue where it is arguably beyond the competence of Parliament to start interfering with the treaty which was signed between the Crown and Maori in 1840.
Thanks, Ginny, and then Takata.
Kia ora, nice to hear from you. Some submitters this morning, we've heard that this bill is required because our judges are not democratically elected as opposed to us politicians. I'm interested to hear your views on that, specifically on whether or not that undercuts some of the key separation of power doctrines that underpin our system.
Oh, but you hear these comments every once in a while. When the first Ngāti Apa decision came out in 2002, there were all sorts of screams about activist judges and so on. In actual fact, the decision was in line with ancient principles of common law. So I don't pay too much attention to that kind of debate. And the last thing we want in this country, Ms. Anderson, is a politicisation of the judicial appointments process, which has worked incredibly well, regardless of Labour or national administrations. Attorneys General I have known over the years have always done their best to appoint judges who will do justice and administer the law. And the last thing we want in this country is sort of confirmation hearings like happened in the United States Senate with Brett Kavanaugh. So I pay no attention to those sorts of comments because they're meaningless.
Can I say one thing? And when you're in a soundbite, what advice do you give, and how do we accurately communicate to the New Zealand public the importance of that, and get around that sort of dogma that it's a left-leaning judge giving light sentences or being activist?
Because from time immemorial, both administrations, centre-left and centre-right, have appointed people who will administer justice according to the law, and I've never had any doubt that if a judge may be of a left-wing or right-wing persuasion, they won't end up doing justice for the people before them. We have the best system of appointment of judges in New Zealand. We have a judiciary that is extremely talented and hard-working, and we don't want to go down that path of attacking the judiciary as happens in the United States. We're too good for that.
Thank you.
Thank you, Chris. We'll go to Takata and then Joseph.
Tēnā koe, Chris. The principles are being talked about a lot, and in my view, they're being sort of painted as the bad guy and helping to generate all of the discussion, and which is largely misinformed. Now, I'm probably a little bit privileged in that I've had a very clear explanation of where and how the principles come about from Tai Hakure. So I'm just asking, I want to ask you if you can give us some clarity on where and how and why principles come out of Te Tiriti o Waitangi.
Well, there aren't many principles, and they're all reasonably benign. To act with dignity towards one another, to properly consult tangata whenua, to protect their treasures and so on. I don't want to send you away to do your homework, but many years ago, Doug Willerton, the New Zealand First MP, introduced legislation to delete the principles of the treaty from the legislation. And I was in opposition at the time and gave what I thought was quite a good speech summarising the principles. And so you may want to go Hansard in 2006 and dig those out. But look, they're pretty innocent principles. They've been interpreted in a very conservative way by the judges over the years, and this really is a case of much ado about nothing.
Thank you, Chris. We'll go question from Joseph.
Good morning, Chris.
Good morning.
In the written submission, New Zealand Law Society has said that Te Tiriti is what it is, a treaty using particular words between the Crown and the chiefs who signed it. There's been quite a bit of discussion in the public domain about wānatanga and tino rangatiratanga. I just would like to get your thoughts on what tino rangatiratanga means in terms of, in the Te Reo Māori version, it's guaranteed to the chiefs, the rangatira, the hapu, and te kinatanga whakapua. And if I look to Henry Williams, the translator of the treaty, who was commissioned by Captain Hobson to interpret and explain the treaty, not allowing him to sign it until he fully understood it, said in a letter in 1847 to Bishop Selwyn that he had explained it as meaning the Queen of England confirms and guarantees to the chiefs and tribes and to each individual native their full rights of chiefs, their rights of possession of their lands, and all the other property of every kind and degree. Do you think that is an accurate reflection of what Tino Rangatiratanga means?
Well, the way I look at Article 2 is Rangatiratanga it gives protection to the taonga of the chiefs, the iwi and the hapu, and that's played out and been played out in cases over the years. But essentially, it's we recognise the authority, the stewardship, the leadership of rangatira, and the right to protection of their taonga.
This is something I could, Mr. Chair. Do you accept that is also extended to the individual?
The individual who?
The individual native, as was framed by Henry Williams, Archdeacon Henry Williams, in his letter in 1847.
Oh, I've given you the answer based on what I consider to be Article 2 of the treaty, glosses on letter that may have been written in 1847, which were referred to by the New Zealand Law Society. You can ask them.
Thanks, Joseph. We've got a final question from Tim Paul.
Kia ora, Chris. Quick one. For someone who is not a lawyer, aka me, what does this mean for settlements and what does this mean for jurisprudence if this bill were to come through via second reading or via a referendum?
Oh, that's actually a very interesting and very lawyerly question with respect, because one of the issues that may be raised is if there are certain rights which are confirmed on settlement, and I refer particularly to the Ngāi Tahu Claims Settlement Act 1992, be very careful what you wish for, because it may give Ngāi Tahu a lot more authority in and over Te Waiponamu than Mr. Seymour and his cohorts intend.
Thank you, Chris.
That has been the subject of some comment in recent times, but it's an excellent lawyerly question, and you should go and see the commentary that's been written on that.
Thank you, Chris. That's the time we've got. I'm not sure something called loyally is often a compliment, but in this instance, it definitely is. So appreciate you being with us this morning and wish you the best.
I really like the submission from Chris. Yeah, he puts it so well. I agree with him. The bill is misconceived and it does not reflect the relationship between the Crown and tangata whenua, and that's because it wasn't done in participation with iwi and hapu. And I'm going to try and keep this monologue a bit shorter. So, tino rangatiratanga, right? This wording here alone, and I'm not a lawyer, but this wording here to me as a reader tells me that this is an agreement between two governing parties. It's not an agreement between necessarily races, but between rangatira, the chiefs, and the Crown. So it's right there in black and white. And what it does is it gives full rights of chiefs and protection of assets. And this is why, I say that this is not a right that you would necessarily give to the average Joe. This is a right that you would give to someone who is in a position of governance. Protecting the full rights of chiefs, again, it's right there in the translation. It's not saying the full rights of Joe down the street or Hone, so it's not a contract necessarily between races, but between governing parties.
Yes, and it was amazing to see the chasm of opinion between the Bar Association and council who are speaking out on their own, like Gary Judd.
Yep. I really liked that submission. That was good.
Yeah, absolutely. All right, shall we go to the next one then?
Absolutely.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok, News Guide, The Order Paper Podcast. YouTube, Twitch, Instagram, TikTok, News Guide, The Order Paper